Senator Schiff.
Chairman Tillis, thank you for bringing us together for this important hearing on patent eligibility. As I do not have a Tillis rule, and as I am a freshman, I will be running off to vote. And as I have a resolution that may come up this afternoon, depending on where Senator Tillis is on that resolution, I may ask you to keep him here, especially if he is the decisive vote. The right to patent inventions is enshrined in Article 1, Section 8, Clause 8 of our Constitution. Even back in 1787, the framers knew it was important to prioritize and protect innovation. Over 200 years later, their foresight has cemented the United States as the worldwide leader in innovation. The Constitution grants inventors the exclusive right to their respective discoveries for a limited period of time. On that point, everyone agrees. Where experts, stakeholders, members of Congress often disagree is exactly what qualifies as a discovery. Thomas Jefferson believed that any new or useful art, machine, manufacture, or composition of matter, or any new or useful improvement thereof was eligible for a patent. In 1952, when Congress recodified Jefferson's original language, they swapped the word art for process in what we now recognize as Section 101 of the Patent Act. In Diamond versus Chakrabarty, the Supreme Court recognized Congress's intention for anything under the sun that is made by man to be patentable. Yet the court also wrote that this is not to suggest that Section 101 has no limits or that embraces every discovery. The Supreme Court has long recognized explicit limits on patent eligibility. Laws of nature, physical phenomenon, abstract ideas are not eligible for patent. The first miner to discover gold in the earth could not patent the mineral, and the first person to find an apple in the wild could not patent the fruit. And I speak with some authority on that matter, as I am Adam and I'm married to a woman named Eve. If you could patent the first apple found in the wild, we would own that patent. Similarly, Einstein could not patent E equals mc squared, and yes, my wife is actually named Eve. Einstein couldn't patent E equals mc squared. Archimedes could not patent pi. Pythagoras could not have patented the Pythagorean theorem. The courts have long held that these discoveries are manifestations of nature, free to all men and reserved exclusively to none. While it is important to have clearly established exceptions and guidelines around patent eligibility, many inventors, patent attorneys, and even judges on the Federal Circuit, where the Appeals Court of Jurisdiction, which is the Appeals Court of Jurisdiction for patent cases, have bemoaned the current state of the law as muddled and unclear. 4 Supreme Court cases in the 2010s, Alice, Mayo, Bilski, and Myriad, have collectively created uncertainty around the patentability of various technological and medical innovations. In the middle of the artificial intelligence technological revolution, clarity and stability around the proper interpretation of Section 101 is necessary to ensure that America continues to win the international innovation race. It is equally important that biotechnology companies have clarity as they work to invent life-saving medical diagnostic tests and other treatments. As members of Congress, we must ensure that we are striking the right balance. If algorithms or technological inventions that simply duplicate pre-existing processes on a computer or on a chip are patented, it could have the reverse effect of stifling innovation rather than encouraging it. Similarly, if one company is able to monopolize a medical diagnostic test without guardrails, that could lead to less patients receiving proper treatment as opposed to more. It's our job to figure out the proper balance between encouraging investments in innovation and ensuring that as many Americans are able to reap the benefits of that innovation as possible. I look forward to hearing our witnesses today and learning more about the current state of patent eligibility law in the United States. I look forward to exploring the steps that we as members of Congress can take to bring much needed clarity to the law, and I want to express my gratitude again for Chairman Tillis and Senator Coons for taking on this extremely important but complex issue, and I yield back.